Hello and welcome to this last day revision video for Insolvency Bankruptcy Code 2016. So I have just picked up 23 important points which can be helpful or which I feel can be asked in the exam or most likely to be asked in the exam. So I'll be discussing only those 23 points. I'm not teaching you guys IBC. This is just the revision video for your exam, and this is, like as I say, this is the last day revision video. So just at the end of nick of time, if you are not even able to revise the entire IBC portion, at least go through these 23 points. You'll be able to get through with IBC. Most likely you'll be able to get through with IBC. So the first point that you have here is the preamble of IBC. This is the objective of IBC. So any question if you get why you needed a insolvency bankruptcy code, why IBC was needed, so you will have some 7 objectives here when it comes to the setting up of IBC. So IBC was the act which was to consolidate and amend all the laws relating to insolvency and resolution of corporate person, partnership firm and individuals. So earlier we had different laws dealing with the insolvency for individuals, for companies and for partnership firms. Now we have only one law. One is this. Second, it is to be done in a time bound manner. So earlier the time foundation was not there, so the insolvency process used to go on and on for multiple years, but now it is for a time bound matter. Then it is for the maximization of the value of the assets of the person, promote entrepreneurship, availability of credit, ensure that the credit is available, then balance the interest of all the stakeholders, also altering the order of the priority of the government dues. So under the Companies Act, when you see the waterfall provision, when a company gets it liquidated, the government dues were into the preferential creditors. The government dues, they were the preferential creditors, but now they are not the preferential creditors. They are being reduced. I mean, their hierarchy, they have been put into the lower level at the hierarchy when it comes to the payment of the government dues. Then the need for IBC was, or the objective of IBC was, to establish the regulator, that is the Insolvency and Bankruptcy Board of India. So all this was the need for IBC. So whenever you get a question why there is a need for IBC, you can write this. Apart from that, if you want to write with respect to the IBC, why IBC came, in that case you can also write, you can start from SICA, that SICA Act was there. Now SICA Act, the problem in SICA Act was that it covered only SIC industrial companies, and also SICA Act used to come into the picture when the company has already eroded its net worth. So IBC doesn't wait the company to erode its net worth. A, B, it not just covers the industrial undertaking, it covers every corporate person, company, LLP. It also covers the partnership firm and also the individuals. Then after SICA, we had the DRT, which was again a dedicated tribunal for the insolvency, but in DRT only the banks and the financial institutions could go. Then we had SARFACI, and SARFACI, there was a lot of political problem. The rising NPA crisis could not be resolved after SARFACI Act. This act came in 2002, and even after 14 years, like IBC came in 2016. So for that way, I'm saying 14 years, SARFACI couldn't live up to what was the expectation behind setting up of SARFACI Act. So do mention all these things. Whenever you get a question regarding the evolution of IBC, do write all these things. When they ask you why there is a need for or what is the objective of IBC, do write this preamble. Thereafter, you can get the second question which you can get is IBC is applicable to. So IBC is applicable to any company which is incorporated under the Companies Act or any of the previous company law. Then any other company which is governed by the Special Act, a limited liability partnership, and any other body corporate which for time being in force is notified by the central government. Then you have the personal guarantors to the corporate debtor, to whom also them also IBC is applicable. Then partnership firm, proprietorship firm, and also the individuals other than the personal guarantors to the corporate debtor. So what is the difference between point number E and point number G? So you have one person, let's say this is Mr. Raj. Okay, Mr. Raj is the director of, let's say, Raj Industries. So when I say Raj Industries have taken loan, okay, Raj Industries have taken loan, and when Raj Industries took loan from, let's say, ICICI Bank, at that point of time, Mr. Raj gave his personal guarantee to ICICI Bank that Raj Limited is not going to, or the Raj Industries is not going to default. If it defaults, then Mr. Raj is going to personally pay the money to ICICI Bank. So he is the personal guarantor to the corporate debtor. So he is covered in point number E. But let's say Mr. Raj took loan in his personal capacity, then he will fall under the category of clause G, that is the individuals. Then you have certain points. The next important point that I'm going to cover here would be the definition. Okay, so you have this. When is the IBC, like CIRP process, the insolvency resolution and the liquidation of the corporate person. This is part two. And in that, we have the CIRP process, corporate insolvency resolution process. So when is the CIRP which can be initiated? The CIRP can be initiated when the corporate debtor makes a default and the minimum default is of 1 lakh rupees. Nah, now this has changed. This is now what? This is 1 crore rupees. So this is the amendment, and this is amendment with effect from December 2020 attempt. I'm not saying year. This is for the December 2020 attempt. This is the amendment there. Thereafter, you have the definition. So I would say the definition of the financial debt. In case you get a question, what is the definition of financial debt? And you don't remember anything. So do mention financial debt means a debt which is along with the interest, okay? Debt along with the interest, which is disbursed. The loan was given, the financial debt was given, disbursed for the consideration of time value of money. Do mention this time value of money. After that, you can write money borrowed, okay, amount raised under the acceptance of any credit facility, right? Then again, debentures, bonds, by the issue of bonds. So all these you can write. Thereafter, also mention this thing, allotee, okay? The allotee under the real estate project is also called as a financial, it is also a financial debt, and any person to whom the financial debt is owed becomes the financial creditor for that corporate debtor. Next, you need to see is your operational debt. So in case you get a question for operational debt, though the chances are very, very less, but operational debt means the claim with respect to the provision of the goods. So three things are there: provision of the goods, including the employment. Okay, your let's say including employment means your outstanding salary and wages, and debt in respect of the payment of the dues arising under any law for time being in force to the government. So all your taxes, duties, everything will be operational debt. So provisions for the goods and services, then your employees outstanding salary and wages, and the debts which are payable to the government. So this is the operational debt, and any person to whom the operational debt is owed becomes the operational creditor. Thereafter, if you see, in case of IBC, next point that I'm going to cover is again who can initiate the CIRP. So whenever a default happens, the default of 1 crore rupees minimum, whenever the default happens, a financial creditor or an operational creditor or the corporate debtor itself can go and file the application to the NCLT for initiating the CIRP process. Then how can a financial creditor do that? So financial creditor can either go itself, or financial creditor can go jointly with the other financial creditors and file the application for the CIRP at the NCLT whenever the default has taken place. Now there is an amendment also here that the real estate allottee is a financial creditor, but a single real estate allottee cannot go and file the application for the CIRP. If a real estate allottee wants to go and file the application for CIRP against a corporate debtor, then that should be either 100, okay? So either 100 allottees should be there, or 1/10 of the total allottees would be needed if a financial creditor who is a real estate allottee wants to file the application for the CIRP, whichever is less. Obviously, whichever is less would be needed. So otherwise, a single creditor can go and file. A single financial creditor can go and file the application. A single financial creditor can also file the application along with the other financial creditors. But when it comes to the real estate allottee, this is the amendment there. Either 100 or 1/10 of the total allottee, whichever is lower, would be needed to file the application for the CIRP. Now, when the application is made by the financial creditor needs to submit the record of the default. Then the financial creditor will also have to propose the name of the resolution professional who is going to act as the interim resolution professional for the CRP process, and any other information which is required by the board, that is the IBBI. After that, NCLT will take 14 days time to just verify the default, ascertain the existence of the default, and within 14 days, NCLT is going to accept the application and the CIRP is going to commence. However, now this is also amendment there that NCLT may take more than 15 days time, more than 14 days time, but if it does so, it needs to record the reasons, right? The reasons is to be recorded right, in writing why NCLT couldn't ascertain the default within 14 days. Thereafter, if NCLT is satisfied that the default has not taken place and there is, I mean, the default has taken place and there is no disciplinary proceeding which is pending against the proposed resolution professional, in that case, NCLT is going to accept the application. And as soon as the application is admitted, that becomes the date of commencement of the CIRP process. Now, next point that we have is the initiation of the CIRP application by our operational creditor. So the operational creditor will first have to deliver the demand notice to the corporate debtor regarding or asking for the payment or the proof of the payment, right, whenever the person defaults. Now within 10 days the corporate debtor will have to either submit, so within 10 days the corporate debtor, once the demand notice is served, within 10 days either the of corporate debtor is going to prove or is going to submit the existence of dispute. Now dispute can be by way of a suit, or it can be by way of a arbitration proceeding, or it can be by any other way, but this dispute should have been existed when the demand notice was served, and the dispute should not arise after the demand notice is served. So either the corporate debtor is going to submit the notice of dispute. If the notice of dispute is there, then the corporate debt operational creditor cannot proceed with the application. But if there is no notice of dispute, then either the corporate debtor will make the payment or the corporate debtor will submit the copy that the payment is made. If the payment is made, again no application would proceed because again the payment is being made, so there is no default. But if the operational creditor, if the corporate debtor does not make the payment or it does not reply to this demand notice, thereafter under section 9 the corporate debtor would be now liable. I mean, the operational creditor would submit the application to the NCLT. And when the creditor is going to submit the application to the NCLT, it is going to tell to the NCLT that we have complied with section 8. That is, we had submitted the demand notice to the corporate debtor. The corporate debtor has not submitted any payment receipt or any proof of the payment, or the corporate debtor has not raised any dispute, or there the dispute does not exist here. So in that case the NCLT is going to accept the application if NCLT is satisfied that there is a default. Okay, so the application is complete, the NCLT is going to admit the application. If the application is complete, there is no payment of the unpaid operational debt, the invoice, that is the demand notice, was delivered by the operational creditor, and there was no dispute which was received by the operational creditor, or there is no dispute, in that case the NCLT is going to accept the application. Now when it comes to the disciplinary proceeding of the resolution professional, so operational creditor may or may not propose the name of the resolution professional who is going to act as the interim resolution professional. However, if it does, then in that case the disciplinary proceeding should not be pending against such a resolution professional. Now once the application is admitted, we will say that the CIRP process has commenced. Now, if the corporate debtor wants to submit the application for initiating the CIRP, corporate debtor would first have to pass the special resolution if it's a company, and if the corporate debtor is a LLP, then 3/4 of the partners must agree for the initiating of the CIRP. So they will go to the NCLT and they are going to provide the information which is related to the books of accounts of the corporate debtor and all the information uh, which is related to the resolution professional. So here the corporate debtor, when it initiates the application for the CIRP, they'll have to propose the name of the interim resolution professional. Okay. And as I said, the special resolution is to be passed, or at least 3/4 of the total number of the members, that is the partners, must agree for this application. Again, NCLT is going to take 14 days time, and within 14 days time NCLT is going to admit the application if the application is complete and there is no disciplinary proceeding pending against the proposed resolution professional, or else the application is going to be rejected. Once the application is admitted, within 14 days, right, the NCLT is going to the CRP process has commenced. Now, one thing is very common in either the application which is filed under section 7 or section 9 or section 10. NCLT is going to take 14 days time to ascertain the existence of default and go through the application. Within 14 days, NCLT is going to either accept the application or it is going to reject the application. If the default could not be ascertained within 14 days, then NCLT is going to take further time and the reasons would be recorded in writing. Also, if there is a defect in the application, NCLT may give 7 days time to rectify the defect. Now, this 7 days time is optional for the NCLT. It is not mandatory on the NCLT. If NCLT deems fit, then NCLT may give the application or the applicant a 7 days time to resolve the whatever defect is there in the application. So these are some of the common points which are there when we talk about initiation of the application or initiation of the CIRP against the corporate debtor. Now, this is again an important question. This has been asked multiple times, that who are the persons who are not entitled to make the application. So the corporate debtor who is undergoing the CIRP process cannot make the application for initiating the CIRP. Then the corporate debtor which has just completed the CIRP process and a period of 12 months have not been completed, right, from the date of making of the application. Again, the CIRP process cannot be initiated, or the corporate debtor or a financial creditor who have violated any of the terms of the resolution plan which was approved by the NCLT in the preceding 12 months before the date of making of the application. In that case, again, they cannot go to the NCLT for initiating a CIRP, and a corporate debtor against whom the liquidation order has been made. So if the liquidation order is made, again, the application cannot be made by such a corporate debtor for initiating the CIRP. So this can be a perfect 3-mark question, or it can also be asked for 5 marks. Further, if you see, this is again an important point, that what is the time limit for completing the CRP process. So time limit for completing the CRP process is 180 days. Okay, 180 days from the date of the admission of the application. However, a single extension can be given for 90 days. A single extension of maximum 90 days can be given. Okay. Now, if the extension is given only for, let's say, 60 days, so further extension of 30 days would not be allowed, because only one extension, and that too for maximum 90 days, can be allowed, right? So this is for the normal CIRP. However, if it is a fast track CIRP, the timelines is totally half. It is 90 plus 45 days. Thereafter, if you see, this is again an amendment there, that though we have 180 plus 90 days, but we had seen in a lot of cases where the writ petitions used to be filed to the High Court also or to the Supreme Court, and all those petitions used to delay the entire timeline process here. Now they have made a or they have added a proviso to this, and they have said that overall time period is 330 days. So within 330 days from the date of the commencement of the insolvency, right? That is the date when the application is being admitted. From that day, within 330 days. So what is the time limit which you have to write in the answer? So you are going to write the time limit for completion of the CRP is 180 days from the date of commencement of the CRP. However, a single extension can be granted for 90 days. Okay, a maximum period of 90 days, single extension can be granted. Full stop. Then again, you are going to write, however, or maybe you cannot write however twice. So you can write 180 days from the date of the commencement of the CRP process. Thereafter, a single extension can be granted for 90 days if the CRP process is not completed within 180 days. However, the entire CRP process must be completed within 330 days, including any extension which has been granted for the legal proceedings. So this is a important amendment there. Then we have this point number 14, which talks about the withdrawal of the application. Okay, so the application which has been admitted by the NCLT against the corporate debtor for the CIRP. Earlier it could not be withdrawn. Once the application is admitted, it could not be withdrawn, but now the application can be withdrawn, but it will be at the option of the NCLT, because that's what they say, the adjudicating authority may allow the withdrawal. So it is at the option of NCLT. And when NCLT is going to allow that, when the applicant who had made the application along with 90% of the committee of creditors agree to the withdrawal of the application, only then the application can be withdrawn. Then as soon as the application is filed, or the commencement of the CRP gets commenced, in that case the moratorium period is set, and when the moratorium period is set, all the legal proceedings get a stay, right? Now the corporate debtor cannot transfer, encumber, alienate, dispose of the assets, right? It cannot again create any security interest on the assets, right? On any action which was to be taken under the SARFAESI Act will again get a stay. However, the writ petition can be filed to the High Court and Supreme Court. This is not written here. This is I'm telling you from the case study. The writ petition can be still filed to the NCLT, to the High Court and the Supreme Court, right? So that there doesn't get a stay. Now, the moratorium period is applicable on the corporate debtor, but not on the personal guarantor to the corporate debtor. So if the moratorium has been set on Raj Industries Limited, Raj Limited cannot say, or Raj cannot say that ICICI Bank, you cannot proceed against me because I was a guarantor to this corporate debtor to whom the moratorium is applicable. The ICICI Bank can proceed against the personal guarantor to the corporate debtor even if the corporate debtor is under the moratorium period. So this is the 16th point which I want you all to remember. Thereafter, uh, some of the important points which you can cover here is again the committee of creditors. So the committee of creditor will comprise of all the financial creditors of the corporate debtor. However, if the company does not have, if the corporate debtor does not have a financial creditor, or all the financial creditors are related party, in that case 18 largest operational creditor will form the committee of creditor along with one representative from the workmen, one representative from the employees. So this would be the composition of the committee of creditors. Then if a person is both financial creditor as well as the operational creditor, what will be his share in the COC? So his voting share in the COC will be determined only by the share of his financial debt and not by the operational debt. Sir, what if the operational creditor has assigned the debt to the financial creditor? Does not make a difference. Even if the operational debt has been assigned to the financial creditor, the debt still remains operational. It does not become a financial debt. So these 2 points say that the voting share would be determined only by the financial debt, only by the financial debt. Okay. Thereafter, if you can see, there is another point which I would want to discuss. I've just marked those points beforehand so that I don't miss out any when I do this or when I record this lecture. So then you have this point, approval of the committee of creditors. Okay. So when we talk about approval of the committee of creditors, so there are certain actions which the resolution professional will have to take, and he will have to take only with the prior approval of the committee of creditors. If he takes any action without the prior approval of committee of creditors, those mentioned in section 28, such action would be void ab initio. So if he has to raise any interim finance in excess of the amount which is decided by the committee of creditors, or if he has to create any security interest, change the capital structure of the corporate debtor, record any change in the ownership of the assets, okay, then again undertake any related party transaction or amend any constitutional documents, MOA, AOA, or the LLP deed, then delegate its authority to any other person, right, dispose or permit the disposal of the shares, right, manage, make any change in the management of the corporate debtor. So all these changes, if he is going to make, such decision has to be taken by the committee of creditor, and the voting share would be 66%. If 66% voting share is not taken, or if such decisions are taken by the resolution professional without the approval of the committee of creditors, in that case such a decision would be void, right? Then we have this point that there are certain persons who are not eligible to submit the resolution plan, and those persons are undischarged insolvent, okay, then a willful defaulter cannot submit the resolution plan. Then at the time of submission of the resolution plan, if the account of the corporate debtor, right, if the account of the corporate debtor was a non-performing asset, or the account which is a non-corp, if the person who is the promoter holding a non-performing asset, right? In that case, such a person cannot submit the resolution plan. So it's as good as you are holding a company, okay? You are holding an account, or you are a promoter of a company which is being classified as a non-performing asset by the bank. Now you cannot come to rescue another company which is undergoing a CIRP process. First clear all your dues, only then you will be eligible. So that's what is given here, provided that such person will be eligible to submit the resolution plan if such person makes all the overdue payments along with the interest relating to the non-performing asset before submission of the resolution plan. Then if it's a financial entity, so if it's a financial entity who wants to become a resolution applicant, but the resolution applicant is holding a account of a NPA, still that person can be eligible. But for that, you just need to see one situation here. And the situation is, let's say State Bank of India gave loan to Kingfisher Airlines. Okay. Now Kingfisher Airlines is a NPA. So technically Vijay Mallya, the promoter of Kingfisher Airlines, Vijay Mallya cannot be a resolution applicant. However, if before submitting the resolution plan, Vijay Mallya clear all the dues with respect to the Kingfisher Airlines, then Vijay Mallya would be eligible. But now we are not talking about Vijay Mallya. We are talking about State Bank of India. So State Bank of India has given loan to Kingfisher Airlines. Kingfisher Airlines has defaulted. Kingfisher Airlines has become now NPA. Now Kingfisher Airlines has also taken loan from some other bank. Let's say it has taken loan from Bank of Baroda. Okay. Now SBI was the largest lender of Kingfisher Airlines, and what it did, it converted its loan into debt, right? CDR, corporate debt restructuring. It converted its debt into equity, and that equity amount was so huge that now State Bank of India has controlling interest over Kingfisher Airlines. Let's say Kingfisher Airlines has now, I mean, State Bank of India has now, let's say 58% of the equity shares of Kingfisher Airlines. Why? Because the loan was converted into equity. Now, technically, State Bank of India is controlling, State Bank of India has now become the promoter of Kingfisher Airlines. So, can State Bank of India be classified as an ineligible applicant? Answer is no, because State Bank of India is a resolution applicant, which is a financial entity and is not related to the corporate debtor. And and here the State Bank of India has become the promoter of this company only due to the conversion of debt into equity. Then if the person has been convicted for any offense along with the imprisonment for 2 years or more for the acts which are specified in 12th schedule, you don't need to know which all acts are there in the 12th schedule, but you need to know this: 2 years or more for the 12th schedule and 7 years or more for any other law. So in that case, the person cannot be the person cannot be a resolution applicant here. If the person is disqualified to be acting as a director under the Companies Act, then again in that case the person cannot be a resolution applicant. If the person is prohibited by SEBI to submit, I mean, to do trading or in the securities or access the securities market, again the person cannot be a resolution applicant. Or if the person was a promoter or was in the management or control of the corporate debtor which was found to be involved in preferential transactions, undervalued transaction, extortionate credit transaction, or fraudulent transaction. So all these are avoidance transactions. So if the corporate debtor was found under doing these transactions and you were the promoter of that corporate debtor, or you were in management or in control of that corporate debtor, in that case this will be this will make you ineligible. However, if such transactions had taken place when you were not in control, when you were not in the promoter of the corporate debtor, then in that case you would say that mera kya kasoor. So in that case you will be allowed to submit the resolution plan. Then if you have executed a guarantee in favor of a corporate debtor and the application for that corporate debtor is pending or is being admitted under the code, and the guarantee was invoked by the creditor and the amount remains unpaid, in that case you cannot submit the resolution plan. So take it this way: let's say this is ABC Limited. ABC Limited took loan from, let's say, ICICI Bank, right? For which, let's say, Mr. A was the corporate, I mean Mr. A was the personal guarantor. So let me just see. Yeah. So Mr. A was the personal guarantor here. Now, if I say ICICI Bank has filed the application against CIRP for the CIRP of ABC Limited, that application is admitted. In that case, Mr. A will become ineligible if ICICI Bank invokes, right? ICICI invokes the guarantee. Okay. Mr. A was the personal guarantor to this company, ABC Limited. Now, ICICI Bank has invoked the personal guarantee and Mr. A has not paid the amount to ICICI Bank for the dues of ABC Limited. In that case, Mr. A will become ineligible. However, if this is not invoked, then Mr. A will be eligible. Thereafter, any other disability or any similar disability which is being attracted to a jurisdiction outside India, in that case, you will become ineligible person. So section 29A, I feel, is very, very important. Be very careful what is asked. It is asking who persons or who are the ineligible person to submit the resolution plan, okay, or who are the person who are ineligible to be resolution applicant, then it is section 29A. If they ask you who are the person who cannot file the application for CIRP, that is your section number 11. So be very careful what question is being asked and accordingly please write the answer there. Thereafter, if you see, okay, so this was another submission of the resolution plan. So this amendment was made. Okay, here there was an amendment. When the resolution applicant submits the resolution plan, at that point of time, the operational creditors must be given at least the liquidation value, at least the liquidation value, or if the company gets liquidated today, whatever amount would have been paid to the operational creditor, that much amount should be paid in the resolution plan to such operational creditor. So be careful with this case. Then the last point that I would like to discuss would be your approval of the resolution plan. So NCLT, if it finds apt the resolution plan or is satisfied with the resolution plan, then NCLT will approve the resolution plan, and that resolution plan would be binding on the company, okay, on the employees, members, creditors, including the central government and state government. A quick fact: 66% voting share is required by the committee of creditors to approve the resolution plan, right? 90% of the voting of the COC is required to withdraw the application. Otherwise, it is all 51%. So the voting share of COC, which is required, is always what? It is 51%, except where something else is mentioned, like to approve the resolution plan it is 66, to withdraw the application is section 90. So these are some of the points which I wanted to discuss under IBC as far as the CIRP process is concerned during the last minute or the last day revision video. If you have heard the video till here, please do like the video and also share this video. Thanks for listening. Take care. Bye bye. All the best.